What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Thursday. Hope you guys are all well. I had already put out 2 videos today. It's been a good day. Hope you guys are all good. Who wants to watch some cord? I want to watch some cord. I've got some cord. You guys want to watch some cord? Let's watch some cord. All right. We got some Judge Simpson clips to start off the day. He had a wild docket. We had a sovereign citizen. Judge Simpson doesn't see a lot of sovereign citizens. Yeah, we had one today. That was in my video earlier. First clip is the guy right before the sovereign citizen. He's a pro se guy. Doesn't end well for him. Second part. Yeah, you know what? Let's go one clip at a time. Anyways, you guys are awesome. Before I hit that play button, Heather, the beautiful Heather, 6 months. That means I've been monetized for 6 months. That is insane. No, that doesn't count the demonetized. Yeah. Heather's the original member. So when you see 6 months on there, yeah. It's good. That's good. All right. Let's watch some court. Thank you, Heather. Thank you. All right. Judge Simpson, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
Court does call the case. The people of the state of Michigan versus Cody Lee Jolly. We're actually set for, what are we set for? We're set for PCC. All right, state your name, sir.
Cody Lee Jolly.
All right. Mr. Jolly, are you still intending upon representing yourself? All right. I do have to apprise you that in this matter, you were charged with 2 offenses versus criminal sexual conduct in the 4th degree. Well, 2 counts as criminal sexual conduct in the 4th degree. You understand the nature of those charges? You understand the allegations as explained to you during the course of the arraignment in these cases? Okay. The maximum penalty, those are both high court misdemeanors punishable by up to 2 years incarceration, $500 fine plus court costs, mandatory STD testing. You understand that, sir?
Yeah.
All right. You understand that there can be great peril in attempting to try to represent yourself in a criminal matter of this nature? And you understand that the court would hold you to the same standards as I would any licensed attorney in terms of court rules and in terms of court procedure. You understand that? And you understand that the court is not going to try to assist you or help you out in any way?
Correct.
All right. And you understand also, sir, that if you are indigent and cannot afford to hire an attorney, that you would be afforded counsel and could request counsel at any particular time. You understand that?
Yeah.
Okay, very good. All right. So what are we going to do in this case?
Your Honor, I'm covering this case for Ms. Reiser today. She did provide me with the outstanding CD of discovery for the defendant. I understand that the police report has already been sent out to him by mail. And we have the CD provided to the jail staff.
Yes.
If the answer is no, I don't sort of have else. Okay. Could you put it in? Is that acceptable? Is that okay with you guys? Okay. Thank you so much.
All right.
So that's everything we have.
All right. That's all discovery. Sir, what did you want to do next on this case?
Before I start the trial.
Well, you understand that the next step is not that of a trial?
Is this pre-trial?
Oh, okay.
I understand this is pre-trial and we're on the trial.
Mr. Jolly, do you really wish to represent yourself in this matter? I'm a little bit concerned because you don't. Well, but that's not how it works. Okay.
Hello, Rachel. Rachel wants me to use her personal pause today to say hello to everybody. All right, let's do it. Allie Zimmerman, welcome. Skiz Rock, hope you're doing well. Again, Rachel. Jedi, you're awesome. Heather, James, CRD loves tea. Sharon, Marty, legal fiction. Donald, Nunya business. Mama Madre, Kathleen, Mama Jamma, Tammy. Now I think I'm repeating. Donald, you wanted me to say hi to everybody, so I'm just scrolling through saying hi to Birdie. What's up, Birdie? Hello, Sarah. Sarah Oberlander, welcome. Let's see. Therina, of course. Therina, good to see you, Therina. Creighton is in the house. All right. Isn't that special? Good to see you. Sue Gary, good to see you as well. All right. I think I've hit everybody now. All right. So we got it. There you go. You got your pause, and I said hello to everyone that's in the chat. Let's go.
That's what concerns me. You're charged with a high court misdemeanor. Okay. The next step is that we're at a probable cause conference.
That's probable cause.
The next step is a preliminary examination. Okay. And then if you're bound over, then you're going to go through that process once again on the circuit court level.
Okay.
You follow that? Okay, so now understanding that that's a basic procedure, what do you want to do?
Just move forward and just not guilty and basically what preliminary examinations. Okay.
I have no idea what you're talking about. My voice definitely does not go up when I say Heather.
I have this matter. I'm in custody right now. And I was hoping to settle to solve that.
So you want it? You got a copy of the police report, right?
I got the discovery. I did. It was emailed to me.
Okay. So you want a preliminary examination in this matter?
If that's the next step to move on to trial, then I'm trying to get the trial done as fast as possible. But if the preliminary examination goes before that,
Wow. All right. I know, but if it has to break, we just have to break.
Yes, sir.
All right. Set preliminary examination for April 23rd, 2024, 9 a.m. That will be before me. That's in person.
in this matter, the custody goes in.
Pardon?
The other day I went to the arraignment. I was hoping that to get released, but there was I had to come here first. I released her.
What do you mean you?
He was arrested. My office had a new warrant request for him from the University of Michigan. It was for trespass and for violating the conditions of Your Honor's bond and that you said in this file. He has been trespassed from the University of Michigan libraries numerous times. He was again there, which is where he was arrested on April 5th, 2024. He was publicly looking at inappropriate photos of women in the school library, and other people were able to see what he was doing. He was reported when the police came. They recognized him. They recognized him as the person that they had trespassed times. The report indicates that his shirt was open, exposing his chest, and that his pants were pulled down, but that his genitalias were not exposed as far as they saw. Certainly this is the CSC he's out on bond in this VSC case while he's engaging in this behavior. At the very least, the ongoing trespass is a violation of.
Why are you saying sorry, Skizrock? I am an Aries. I know Aries rock. I am one. And I mean, I rock. I mean, I guess if I have to say I rock, I guess that means I don't rock. So, okay, I get your point.
His bond, given that he's committing a new crime while he's out on bond, and not concerning behavior in a public place, in a place he's in trespass. My office denied the warrant request, and essentially turned to this case and for us to move forward on violation here instead.
All right, sir, you are entitled to a hearing regarding a bond violation on this matter. Did you want to have a hearing on that? Did you want to admit the violation, or did you want to deny it? What do you wish to do?
To admit the violation was what again? I'm sorry. The violation was because when I got here, they told me that everything was, they said that it was, when they came out and gave me this trespass, when I got here, they said the trespasses and stuff, and they weren't worried about it. It wasn't.
Well, they weren't worried about it from the standpoint of new charges.
Okay, yeah.
But my understanding is that the prosecutor doesn't want you released because the conduct that's alleged to have occurred is a violation of the condition of bond on this case.
Okay, yeah, there was nothing inappropriate besides being in the library. Yeah, nothing weird in the library. I have no idea. But yeah, I wasn't.
But you weren't supposed to be back on the property.
That's what they said. I guess that was stemming from this.
Do you want a hearing on it? Or are you going to admit to the violation? What are you going to do? You're entitled also, sir, to have a representation of an attorney for a bond violation here.
But I mean, if it's not a new charge, I admit that I was trespassed. That I was probably trespassing there. I was hoping to get out of jail for days.
Well, I need you to understand that I'm not agreeing that you're going to get out of jail at all. Whether you admit it, do whatever. I'm not.
I'm sorry. I know I've just been saying hi to the chat and not commenting on the video, but why hasn't this guy had a competency evaluation yet? And I'm not saying that people that want to represent themselves need a competency eval. I'm not saying that at all. Some people just think they're smarter than everybody, and that's fine. But I mean, I'm judging this guy purely on what he's charged with, and you know what? This guy is innocent until proven guilty. But these are some really bad allegations. And he's representing himself, and he's not doing a good job. At what point, as a judge, do you say you are not aiding in your own defense? I am no longer allowing you to represent yourself. At what point do you say that? Now, I did ask that question to, I know I asked Judge Slaven, I might have asked Judge King too, and they both had kind of similar answers, but this is one of those times where I think I would pull the plug and I'd be like, hey man, I don't think you can aid in your own defense. You are not saying the right things. You're clearly not understanding what's going on. You say, I don't know, and between every sentence. I guess I do that too. So, you know what? Maybe I'm not incompetent. I'm not competent either to have a channel. I don't know. But this guy, it's bad stuff. Bad stuff.
Well, you just admitted to the violation. That's why I'm worried about you not having an attorney. You admit to the violation of being on University of Michigan property, correct? Okay, so that's why I'm worried about you not being represented by an attorney. Because that's a violation of the bond conditions that I set in the case involving the criminal sexual conduct.
I've never been there before. I wasn't aware that it was allowed to be on public property. I've never been in the building before.
Sir, did you want a hearing on the bond violations? Because I'm gonna take into account everything that they're indicating, that you were trespassing and what was in there. Do you want a hearing on that?
Yes.
Do you want an attorney to assist you regarding that hearing on the bond violation?
I think I'm okay. I just the bond and stuff, we can get it heard. Simple as that. I've done 10 days in jail already, and
Where are you coming up with this 10 days in jail?
just got out.
Yeah, but what do you mean I've done my 10 days?
I've been 10 days so far, and I've not actually had the chargement. I've been charged with these 2 counts that are here, but I've not actually committed the offense.
Do it, Judge. Send him for an eval. Those
Okay, but sir,
those jailhouse lawyers are getting
you
to him.
understand that the criminal charges that are here, that your release on those criminal charges, there were certain conditions regarding your release.
Right, that's what they're telling me.
Correct. In certain places you couldn't go, you couldn't leave the state of Michigan, no alcohol, all of that stuff, right?
The best I can. I've been just 2 months without a problem. The best I can.
Okay, but now I have I have a trespassing, which is a violation of the conditional, your release. And I could, if there's a violation of the conditions of your release, I could certainly let you out. I also could just hold you until this matter gets resolved. You understand that? And now you want a hearing on that. And that's fine. I don't have a problem if you have one, you're going to have a hearing on it. But then the issue becomes, are you going to try to handle this hearing yourself? Or are you going to want an attorney to assist you with that? I understand that you want to move forward, but there's going to be a hearing that's going to determine whether or not you're in custody. Pardon? Well, I haven't set a date. I'm trying to figure out how you want to proceed on it.
Like I said, I'm just doing my best to live my life.
Sir, I understand all of that. Listen closely to my question. This hearing on the conditional bond violation could determine whether or not you're in custody or you're released with other conditions or not, pending the further proceedings in this case. Bottom line, I could come to the decision, okay, well, I'm going to let him out, put conditions on you and you walk out. Or I could come to the decision, no, he's going to be held on this case. I'm going to I'll give him a bond of some type, but he's going to be held. Okay, but you understand what I'm saying?
Yeah.
You'd be held. That's what's at stake.
Yeah, just hope to get out as soon as possible. So I just like to move forward.
Well, I understand that, but follow what I'm saying to you. You say you want a hearing. My question to you is, are you going to try to do this hearing yourself, where one side of it, you might get released, the other side of it is you might be locked up for the remainder of this case? Do you want to try to do that yourself, or do you want the assistance of an attorney to help you through that process?
I think I just hope that just get out of the facts.
Just answer my question. You're gonna handle it yourself.
That everything.
Okay, but you're going to handle it yourself. How soon could we have witnesses available for a bond violation here?
The answer to that question, I apologize.
No, it's okay.
Are you thinking like a week? Is that what you mean?
I'm thinking sometime next week, and then, because the following week is his, what day?
So we would have Tuesday morning available,
The
but
16th.
he's in custody, so I would do that. Because that's pretty much he's in custody. Once we did it,
What, I got stuff Tuesday afternoon.
we have an expungement docket at 1, which is small, so we can do it at 2:00.
I could do it at 2:00 on Tuesday, the 16th.
It's a U of M police officer, so I can email him, 2 U of M police officers, so I can email them and see if one or both of them can be there on that date.
Okay, what I'll do, I'll just set it. If there becomes a problem, we'll communicate with the defendant as well as you, just try to arrange a different time. So set a bond violation hearing, April 16th, 2024 at 2 p.m.
Mhm.
At 2 p.m. There anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tender condition. Because this, 2 months, I think, this will be 10 days, it'll be like 15 days, and by the time that happens. I was hoping that would count for something, as far as the conditions of my bond. Maybe, yeah, I can't pull cash bonds or something, just write a beer out on it, maybe sign it up, got it, you know.
I don't know what you're asking me.
Get the tether.
No one knows what he's asking you, Judge. Order an eval, please. It's time. It is time. Do it, Judge. Do it. University of Michigan Library. So when they first said library, I was thinking it was, some public library and he was in front of kids. Not that it's any better, but it's not where I mean he's in front of adults instead of children. I don't know why I'm even talking. Still. Come on, guy. Come on. Eval him immediately, Judge. All right, let's go on to the next clip. There's only about a minute left of this one.
The tether situation can be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you.
All right. Well, I'm glad that I got that one out of the way before the big raid. Yeah, that one was rough.
Let's call the case.
All right. So this one's still bad, but it's not creepy. Let's order this guy an eval bad. It's bad because, well, let's just say we get a Mr. Allen. Let's just say that. That's all I gotta say. Mr. Allen. Thank you, Biggin, for the raid. If you are listening, Biggin, go enjoy your dinner, man. I appreciate the raid. And you had a great stream tonight. It was a lot of fun hanging out with you for the little bit of time that I was, watching. Yeah. I don't know how you come up with the police body cameras every single day. When I watch that stuff, I'm lucky to watch 1 or 2 a day. I don't know. Anyways, let's go. We're right back in Judge Simpson. And like I said, we get a Mr. Allen. You know what? Oh, that was close. I want to thank I got super chats. I need to call out super chats before I go on. Nickster. I like the new name. Nick. Thank you so much. It's good to see you. Thank you for the $5 super chat. Very generous of you. The very fact that you decide to represent yourself means you shouldn't be representing yourself. I mean, yeah. Yes, I agree with that. But you have the right to represent yourself. And we get a lot of entertainment value of people representing themselves. That guy should not have been representing himself, though. I do think that I don't think it's going to go much further. Like he clearly didn't know what was going on. But thank you so much, Nick, for the super chat. And Tater Todd, I got to make sure I say Tater Todd, not Tater Tot. Tater Todd, I want a hearing too. You know what? I'll give you a hearing. I'll send you the link tree. Not the link tree. I'll send you the StreamYard link, and you can come up here, and I'll give you a hearing. I'll give you a formal hearing, a formal one though. That means you're going to jail if you don't prove your innocence. Let's go.
Do you have a client?
Yes, Your Honor. This is Matthew Mansour, Assistant Public Defender with and on behalf of Mr. Exton, who's approaching to my right. State your name for the record, please.
All right.
Your Honor, there was a community corrections report dated April 9th. You have a copy of that.
I do. What were we? Really?
Your Honor, I'll address this right now. We have no.
That was an alarm. That was an alarm. I know. Your phone could be on silent. Your alarm will still go off. That was an alarm. That tone was not someone calling. Unless you change your tone, your ringtone to that. I don't think people do that. This is, she probably put an alarm like good to be in court today and her phone went off. But I understand your phone should be off. Judge Simpson's right to be frustrated. But you know what? She's there. It was an alarm. All right. It doesn't get any better though. You know, spoiler alert.
Excuses. We will not.
Mr. Allen.
We will not and will never mislead this court. She takes full responsibility for her actions. She thanks this court for allowing her to remain out of custody and to continue to test. You have been fair with her. You've been sympathetic with her. She sincerely apologizes for her actions. I hope the court sees that there is something to be said about her appearance here today to take responsibility. And this is her first positive test since her very first test back in November.
Well, except for the fact that I have abnormal creatinine
I know.
throughout all of these tests.
Yes, Your Honor, that is absolutely true. I don't know what the creatine is. I don't know what could cause
But
creatinine, whatever. I don't know what that is. But I do know what cocaine is, and that is
okay. Well, I don't know if you should say that out loud, but go for it.
Yeah, I did love how the attorney said that. Well, I mean, I do know what this is. Yeah. But I do think it's interesting. This has come up a lot over the last couple of weeks, where I've heard people calling creatine. Now it's two different things, but I've heard attorney. I mean, I know you're an attorney. You're not, in the medical field, but I feel like that's something, especially if you're defending someone who was testing positive for, the white powdery substance. You should probably know what that is. It's not creatine. It's creatine. Just saying.
I do know that she did test for cocaine on her last attempt on the 9th, and the last time she's tested.
I will usually see abnormal creatinine so that you know when somebody is masking a test. Not always the case. So you can place in perspective that I have this test, abnormal creatinine, and then finally it almost appears wasn't masked enough and the cocaine gets picked up.
Understood, Your Honor. We've been doing this for enough time to know that. I just want to let you know.
You have been doing it, or are you saying me?
You, Your Honor.
Oh,
I know.
so now you're calling me old. Go for it.
Oh,
Keep going. You're doing well.
didn't mean to do that. Your Honor, I just would ask this court any leniency possible. I know you know our situation.
I do, but the problem is that then come here today saying all of that, but that's not what she told community correction.
Well, Your Honor,
She denied use to community correction.
Your Honor, she's stating that she did not deny use. Okay, there's a positive test. That's what we're here.
Hold on a second. You want me to get community corrections over here?
Would that help?
Not you, I don't think. She's denying use to community correction. You have.
Okay, all right. Do you want me to get community corrections over here? The defense attorney, would that help? No. The only reason why community corrections would be here is to either say your client is doing amazing or your client's not following what they're supposed to be doing. What do you think they're going to say right now? She's testing positive. Do you really want them to come over right now? Would that help? I don't like talking bad about attorneys, but yeah, sometimes you just gotta, you know what? Maybe you should take back that question.
Have the report in front of you, counsel?
Yes, I do.
Look at the box.
Yes, I
What's
see
it say?
It says denies use. That was,
She's saying that didn't happen.
yes.
So she admitted use.
Now she's admitting use.
No. She's talking to community corrections. What did she tell?
Okay, if that's true, then I apologize. If this is a law student, I didn't know that. I missed the introduction where he had to put on the record that, I am studying under this court rule under the supervision of this attorney. I missed that part of it. So, but I don't have the beginning of this clip. I edited that part out. So I'm gonna say that you might be right, and if I am wrong, or if you are right, then I apologize for that statement.
Community correction.
Can I speak?
You can do, hey, it's
So
up
when
to
the lady,
you.
so before Agent Carr called, the lady called and said it was a illicit drug. I told her I didn't know what illicit, I said, what is illicit drug? And she said, I can't tell you the exact what it is. Call your agent. And when I called Agent Carr and she said what it was, I told her, okay. So I never denied it, but the lady that called from the lab called and just said illicit drugs. And I didn't know what illicit drug was. So that's probably what I came in contact, but I mean, you could ask Agent Carr. I definitely didn't deny use. Once I talked to her.
So then how did the cocaine get in your system?
What you mean? How did it get in my system?
Okay, this is why I don't think he's a student. Because when Judge Simpson said Mr. Allen, I feel like if he was under the supervision, I think someone said Lauren Brown would have walked up. If she has a chance of going to jail, she's not going to have a student attorney representing her. That would be my guess, but I have no idea. All right, let me grab some super chats because Kayla called me out for not saying Colin, shouting her out. All right, the high point for her was getting scolded about her phone alarm. The white powder is a great path to jail. Yeah. Thank you, Tater Todd. Kayla, thank you for calling me out. Go to jail, catch a free bed, hot meal. Hi, y'all. Thank you, Kayla. I hope you're having a great night. Thank you so much for the super chat. And Tater Todd, next time we see her, she's in green or yeah. No spoilers. All right, let's go.
Yeah.
It's okay.
When?
When? I I don't know, a couple of days before.
Anything else?
And the abnormal creatine, I mean, that pops up. I have kidney problems. So that I got a report on it. That's what she probably she wanted. So, I mean, that's been in a lot of my tests and all the stuff still pops up. It's literally in almost every test that I had, but things still popping up from stuff that I'm prescribed and the cocaine.
Anything else? What are we doing with this case?
Well, Your Honor, I spoke with Mr. Ganatra. He was kind enough to honor the offer made the last PCC. I was just trying to ask this court if it had any leniency for this situation.
To do what?
Excuse me?
What were you asking me to do?
Your Honor, I'm asking for any leniency for this bond violation.
Okay, so
she's denying the bond violation. And now her attorney is saying that he's asking for leniency for the bond violation. Did I miss something? I know Judge Simpson said how to get in your system. She's like, I don't know, whatever. She hasn't admitted to it yet, has she? So why is he asking for leniency when this is when you need to take a minute and go sit down with your client. Like, we're clearly not on the same page. So yeah, he might be a new attorney. He does seem a little disheveled up there. I don't think he's a student though. He might be new though. Let's just we'll end the argument there.
On March 14th, she was here. I told her no more missed tests, right?
Yes, you did.
I also gave her an admonishment about how she was treating the people. I'm trying to think at what date I had to do that. Back in December, she was mistreating the people over at Community Correction.
That'd be the 11th.
In December.
Yeah. December 11th, bond violation.
And then don't make it a few months. And then I have to tell her, don't miss tests. And then she tests positive.
Your Honor,
She just seems to do what she wants to do herself.
you wanted me to let you know that she's struggling. And she has a special needs child at home.
Ask for a few minutes. You are talking without her telling you what's going on. She might be struggling, and you can hear her whispering into his ear. Ask for to pass it. Say, hey, can we pass this until the end of this block? Let me sit down with her so we can get our story straight. They are not on the same page. Not even close.
And going through a lot, so
the cocaine helped.
no, obviously not. Look where we're at.
What were you gonna do with the case itself? No.
Yeah. Oh, go ahead, Mr. Gotcha.
There's a plea offer, but I've not written up the plea form while she's got.
Yeah, that's not gonna happen today. How often are you using? Now, young lady, you can, as your counsel has indicated, I guess I'm old and I've been doing this a minute. So you can go ahead and tell me what you want to tell
I mean, I don't want to tell you anything but the truth. I take responsibility for it.
me. How often are you using?
Like, you wanna is it an everyday thing?
I don't know that that's a hard question.
I have a problem with it. I stopped it and I started back.
Was that my question?
But a couple times.
Okay, look, no. Here's the thing. I don't mind trying to find a way, pretty much everybody in this room that's involved in the system, try to have you work this out and try to assist you to try to get past something. But if you don't want to answer my questions, you want to skate around everything, I don't have time for it. So here's what I'm going to do.
All right. I probably should have paused it about 30 seconds ago, but I paused it right at the right time. We have the bufflet, Mr. Allen, standing behind this defendant. So it's about to go down.
Probably a couple of times a month.
Well, now you want to answer me, right? I'm going to adjourn the probable cause conference. I'm going to adjourn it out 1 week to the 18th, 2024 at 9 a.m. This time, given the violation, you can think about what you really want to say. Defendant's bonds revoked, defendants remain.
Yeah. That's why I said that defense attorney, all he had to do was just be like, hey, can we just pass this case for a little bit? We need to get on the same page. The defense attorney was arguing one thing. The defendant was saying something else. Judge Simpson's like, you know what? I'm just going to put you in jail. And he did. Yeah. Anyways, Binky, thank you so much for the super chat. Thank you for the $2. Very generous of you. I'm innocent, Judge. She was very innocent. She was definitely innocent. And you also became a new member. Thank you so much. I very much appreciate it. Hold on. I've been practicing this. I sure do appreciate it. It's getting better. Still horrible. But instead of being a 0 out of 10, I think I moved up to a 1 out of 10. I sure do appreciate it. No, yeah, still a 0 out of 10. I'm going to stop doing that. All right, next clip. You guys are awesome. Right before I hit the play button, you mad jackass. Thank you so much for the $10 super chat. Very generous of you. These people are so lucky they don't live in Wisconsin. They would get bail jumping charges if they did this stuff. Yeah, bail jumping. Different jurisdictions. Yeah, I can't even say that word. Different jurisdictions will charge people for bail jumping, and some don't. Like, you'll get the bail jumping times 6. It's like, what? It's like, oh, you committed 6 new charges while on bail or while on bond, so you got it times 6. Like, oh, just charge it once. But I understand it, but it's different, court to court. Anyways, all right. Next clip. I don't know what's next. I honestly don't. I think this is the short one. The short one? Yeah, this is a short one. Little palate cleanser. This guy's a jackass.
See, Mr. Norton, what are we doing?
Your Honor, I am requesting, as well as my client's requesting, that he be appointed another attorney. I advised him he's going to have to write a letter to me, and then I will forward that to Mr. Nave. I will talk to Mr. Nave because I believe that there's an absolute breakdown of the attorney-client relationship. Mr. Brewer and I cannot agree on anything. So I will talk to Mr. Nave specifically to ask that he be appointed one. I advise Mr. Brewer that he does have a jury pick on May 21st. And so I'll advise Mr. Nave of that also. And again, request that he be appointed another attorney.
All right, Mr. Brewer, what are your thoughts about that?
Yeah, I just want a new attorney, man. This guy do the same thing with everybody else, man. He tried to disaccuse me, keep accusing me of doing what I didn't do. Keep trying to. He's bullshit, man. I need a new attorney. I don't want to deal with him no more. And I request that jury trial get pushed back so I can have more time with my new attorney.
So, Mr. Brewer.
Okay, so translation. This attorney came to you with a plea deal that he negotiated with the prosecutor, and the prosecutor was willing to say, if you plead guilty to this, and this, or maybe just one crime, we're gonna dismiss this, and this, or maybe just the one thing. He's not saying you're guilty. He's saying this was the plea deal I worked out before I talked to you because I'm your public defender and this is my job. I know what you're charged with. I've read the police report. I'm not saying you're guilty, but before I talk to you, I've already spoken to the prosecutor. So what do you want to do? So it's not he doesn't go to you saying you're guilty, plead guilty to this. He's going to you saying this is an option. What do you want to do? This guy just has an attitude on his he's got a chip on his shoulders. Like he didn't go to you saying you're guilty. Just saying. All right, let's go.
I don't mind giving you another bite at the apple, so to speak, with a new attorney. The problem with that is it'll be up to the public defender's office. And then once that occurs, generally you're probably going to be stuck with the next one. All right, do you understand that?
Well, I mean, if the next one don't do what I don't, I'll be representing myself, sir.
Well, you can do that, and then we'll have to go through a bunch of questions to make sure you understand all of your rights and even the disadvantages of representing yourself. So what we'll do then is we will then refer this to, or Mr. Norton will, to the public defender's office. We'll see where that goes. I am going to leave it on, sir, for jury selection. The case has been bound over to circuit court for some time now. Looks like maybe since August. Let me look here. Oh, that's district court.
It was May 14th, or March 14th, Your Honor.
Okay. So not too bad. So we'll see where we get. All right, anything else from either side?
No, Your Honor.
Okay. Sir, you're all set on your end. If you got a correction officer there with you, you can sign off, all right?
Jason, I agree. That's another thing that's different from court to court is, like Judge Stevens, if you decide you don't want your public defender, he will tell you to go hire your own. Like, this is the one you have. So if you want to let him go because you guys aren't seeing eye to eye and you don't have a good reason to let him go, then you're going to be hiring your own or going to be representing yourself. It's just, it's really strange that, different judges, or I'm not going to say judges, different courts, different, let's say jurisdiction again. I said that earlier, you guys, anytime you hear that word, it's, oh, Colin's a South Sid. I am a South Sid. I'm a sovereign citizen. I believe in my personal I could do the script if I was in front of a judge, but I couldn't do it just right here. What do we got? You would have to accuse me of a crime, and then I'd be able to spew it out. Anyways, you're not here to hear me try to recite something I don't believe in. All right, let's go. Next one. What do we got? I think we're going. Yep. This one's a little tough to hear, mainly because the defendant has an accent, and he's not right in front of the mic, so it's a little difficult to hear. But I love this judge. She's really good. She's really good. And her hair's on point. Her hair's on point every day. Just saying.
On the record. In the matter of the people of the state of Michigan versus Divine Foncham, file number 4-00871. Council appearance.
Jeffrey Billabé on behalf of the people, Your Honor.
Morning, Honor. Attorney Derek S. Public Defender on behalf of Mr. Poncham, who is in the courtroom here, seated to my left with counsel table.
How are you, Mr. Poncham?
I'm not doing all right.
You're not doing all right? Why?
Yeah, because I didn't do anything. And my phone number.
Please don't talk about your case. I've told you that about 10 times this morning.
This court is on talks. You didn't go a lot of cops on talks because I saw everything as soon as you got me arrested.
Mr. Poncham, please stop talking.
No evidence.
Mr. Poncham, please.
No, innocent and the case be dismissed. My phone number has nothing because he arrested me by chance, by coincidence. Had nothing to do with this call. My phone number, it is like he arrested me by chance and it has nothing to do with this call.
Okay, you understand that you have the right to remain silent and anything that you say can be used against you, correct, sir?
It's silent.
Okay, and you've spoken with your attorney privately. He's advised you not to speak today, correct?
Yeah, he said something like that.
Okay, but you want to waive that right and speak anyways?
Because it's as if he's letting me to run in jail, and that's the reason why.
Well, he's not letting you to run in jail. He didn't set your bond. he didn't have any control over the charges being issued against you. He actually we brought you up because he said he wanted to make a bond motion on your behalf. Okay, today was the date and the time that was scheduled for a preliminary examination. I have one count of false report or threat of terrorism. Let's see. Are we able to proceed today?
The prosecutors advised me they're not able to proceed. Their officer that they need testimony from is at a promotion ceremony. I don't know.
That is correct.
We're asking the court to dismiss the matter. Mr. Poncham has brought up some of the things I was going to bring up to the court. There was a voicemail of a threat. The voicemail was from an international number, not from his telephone number. There's no connection to him at this point to that number. The only evidence they would have would be a lay witness from the business to try to identify his voice. My understanding is that they were able to say it was him based on the fact that he had an African accent. I don't think that, I guess it would go to the weight of it, but that, without tying him to the phone number, I don't think is enough. We're asking, they took his phone also, Your Honor, and I asked last week about the search warrant phone dump, and we haven't received that yet. So we would ask the court to dismiss without prejudice. That would give the prosecutor's office additional time to do their investigation to get the search warrant if necessary, which I believe it is. They can review that, and if they believe that the case should be reissued, it should be reissued. At this point, I'm asking the court to dismiss without prejudice. If the court is not going to dismiss without prejudice, then I would like to make a bond motion.
Thank you, counsel.
Your Honor, would oppose a motion to dismiss this case. We only had a slight setback with the fact that the police officer who would be able to establish all the facts.
He's sitting down. The very bottom left is his attorney. Gray hair, glasses, that's his attorney. The defendant is sitting down right next to him. You can barely see him. You know, I don't like to shame people, but the attorney's belly kind of covers him a little bit. But that's where the defendant is.
Facts relating to what defendant had done on that day couldn't be here because of another event. So we would oppose motion to dismiss at this time because we believe that is good cause to adjourn the case at this time. As far as the evidence, Your Honor, I think that's our concern. We're not here to argue facts at the moment.
Thanks, Lori.
So that is our side to prove, and when it is time and date to do so, we believe we will carry the burden, even at least by a probable cause. So at this time, we'll oppose a motion to dismiss.
Please be quiet. Please be quiet. Please be quiet.
Thank you. He was ordered to undergo a CATS evaluation. I'm trying to look for the response as to relate to that. If you can't be quiet, I'll remand you. We can carry on this hearing without your interruptions, okay?
I mean, right? They just dismissed one of his charges. Calm down, dude. Stop talking. Oh, and now we have dead air. Yeah, I never know when this dead air is gonna hit. You guys are all awesome. Thank you for hanging out. It's been a really fun night. We still have a little bit to go. But yeah, I really like this judge. She's
Okay. Even if this case were to be dismissed upon your motion, they're just gonna reissue it before he can make it back to Ingham County Jail today. So the motion to dismiss is denied due to the officer being at a promotional ceremony. That's out of his control. we'll reset this matter. You have the right to have a preliminary examination within 21 days of the date that you are arraigned. You were arraigned in this matter on March 26th. The matter was scheduled for an exam today. Due to the officer's conflict in schedule, the court will find good cause to go beyond the 21 days. So I can reset this. You can make your motion.
Now we ask the court to consider PR bond or grant or reducing the bond with appropriate bond conditions. Your Honor, he has no prior criminal history. He's a U.S. citizen, lived in the country for over 18 years, is my understanding. I think the court can order appropriate bond conditions to ensure safety to the public. I don't think there's any concern, at least from my conversations with him, that he wouldn't appear for court because he obviously protests his innocence. The court could have bond conditions such as no weapons, no solid behavior, and GPS monitoring. So I would ask the court to consider reducing the bond because he cannot afford the bond that is set as is, or reducing it to a PR bond with appropriate bond condition. You know, regarding the date, I would ask the court to maybe set it out a little ways to give the prosecutor time, hopefully, to execute the search warrant and get the information off the phone, because that could impact the case, how it goes forward. And he was offered a reasonable plea offer to plead down to a 6 month misdemeanor, which he has rejected.
Everyone that hangs out in Discord has heard me sing, and they've all yelled at me. So yeah, there's gonna be no singing. There's gonna be no singing. I've quit. I've resigned. I've retired. My singing days are long gone. No more singing. So you're welcome. And you guys should all say thank you to the Discord community that told me to stop.
If there's information on the phone, depending on what information on the phone, he may want to reconsider that.
Response to the motion.
Your Honor, we would oppose change of bond at this time. We believe the defendant posed specific danger to society, given the threat and the magnitude of the threats that he's made. He presents himself as particularly dangerous to society, and a PR bond would not be appropriate given the level and seriousness of these charges. And for those reasons, Your Honor, the people would oppose the change in bond at this time.
Okay, I don't see any response in my file as it relates to the CAT's evaluation that he was ordered to undergo by Magistrate Milmore back at the time that he was arraigned. However, Mr. Etheridge, you said something on the record in your bond motion that conflicts with the bond report, which we do have in the file from Ingham County Circuit Court Pretrial Services. You indicated he doesn't have a prior criminal history. This report says that he has a multi-state criminal history with criminal contacts in Georgia and Ohio. In addition, it says that while he was being interviewed by pretrial services by an investigator, he became extremely agitated and started yelling that he would shoot the police officer. He yelled this multiple times upon leaving LPD. Reporting investigator advised LPD detention employees of what was stated.
If that's the case, I would correct my earlier statement. I based that on the notes in the file and on the intake form where it says he has no priors.
Okay, well, based on the bond report and the charges that are alleged, which ironically, the bond report indicates allegations of a statement made that are almost identical to allegations of the underlying issue, which is threats of violence and the use of a gun.
All right, so this is what I think just happened. Now, I was paying attention to chat, so I haven't watched this for a few hours now, but the case that he's in trouble for was dismissed. But his actions while he was being interviewed by the police caused him additional charges that aren't being dismissed. Yeah. And as the judge just said, your actions that were dismissed are really similar to what you're being accused of now. And we just saw in court that you can't stop talking. To quote Judge Perkins, don't talk, you might just walk.
Against the public. The court believes that the bond that was originally set by Magistrate Milmore, $75,000 cash surety, is more than appropriate under the circumstances. Your bond motion is denied. We will reset this
21st at
matter.
9:30.
June,
21st at 9:30.
June 21st at 9:30 is the next date for your preliminary examination.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
No, Your Honor.
No, Your Honor, thank you.
You're all set.
Smart people. Smart people. That's all I'm gonna say. Smart people. All right, what do we got next? What do we have next? Oh, we're gonna finish it off. I got 2 Judge Slaven cases to finish it off. First one's a little lighter. Nothing really happens. Second one's kind of funny. We have the actual and true constitutional law scholar, Judge Slaven, not that weirdo that's in jail in Las Vegas. All right, let's go. You guys are all awesome.
I don't know who's making the noise in the background, but knock it off.
Versus Regina Brown. I didn't think that was the case to call.
Ms. Bailey, are you from Midland Credit Management?
I am, case number ending in 3884.
Right, so I just called that case. All right,
Oh,
Miss
I heard a different case number. I apologize.
Ryan Johnson, I don't know, he's going in the waiting room. There we go, now it's quiet. Ms. Brown, you filed objections to a garnishment. The garnishment is a tax garnishment. You can't object to that. There's nothing I can do about it. That's between the taxing authority. So I have no power to do anything about that. All right, so your objections are denied. If it was a bank garnishment or wage garnishment, I can take care of things like that. Tax garnishment, no.
I thought it was a wage garnishment. The paperwork that I have is saying they want to
tax garnishment. Tax garnishment says right here, writ of garnishment, income tax issued, Department of Treasury, Michigan Department of Treasury. So that's.
Yeah, we haven't filed a wage garnishment in this case.
All right, so
if you'd like to set up a payment arrangement before we do that, Ms. Brown, please contact my office and we can discuss that.
Okay.
All right, so both of you have a good rest of your day.
You too, Your Honor.
So for anyone that doesn't know what just happened, the defendant filed an objection to a wage garnishment when she did not have one. And all she did was put herself out there, and now she's in contact with the company who just said to her, "Oh, we haven't done that yet, but please come and talk to us so we can talk about a payment or a repayment agreement so we don't do that." So she's like wiping her head like, "Oh man, I just messed up. I just lost my income tax and I thought I did the right thing." Nope, you didn't. You didn't. Pro tip, do not fuck around and find out with the IRS. Don't. But yeah, she didn't. Yeah, she got her taxes taken out for something. Yeah. Anyways. All right. Next one. The next one's a good one. That was just a quick one to get you, situated with the going from Simpson to Simmons to Slaven. Oh, we got a lot of S's today. Yeah. Let's go.
All right, in the Mario Lehrmeister versus Michael Steelman matter.
Good morning, Your Honor. Brittany Thompson, P83717, appearing on behalf of plaintiff Mario Wehrmeister.
Aaron Speck, Your Honor, on behalf of the defendants, P38727.
Today is the date and time set for a motion for summary disposition. Parties ready to argue the motion?
Ready, Your Honor.
All right, counsel, this is your motion. Go ahead.
Thank you, Your Honor. This is a license agreement that arose out of some litigation in the Upper Peninsula. My clients, they received this property as a result of the death of Mr. Steelman's father. There was litigation in the Upper Peninsula. This gentleman claimed that he had an interest in the home, interest in doing some improvements at a time when my clients didn't even really have anything to do with the property. But needless to say, they obtained counsel, poorly advised counsel, had them enter into a settlement agreement up in the Upper Peninsula to allow Mr. Wehrmeister to have a license for a term of from June of 2023 through September of 2027. It's akin to a lease agreement, I would imagine, according to the law that counsel has cited. The license agreement, though, that the parties adopted had very, very strict terms to it. One of those terms said, if there's a violation of any term of this license, it results in immediate cancellation. That's paragraph 13 of the license agreement. The occupancy of this was supposed to be starting in June of 23 for through September 27, but it was only on specific times. It was a hunting cabin. The license agreement says that there will be a $500 surety deposit for the term of the lease to be returned upon the expiration. Paragraph 1 of that agreement says the term is specifically called out. When the term began or was to begin in June of 2023, the plaintiff in this case never made any attempt to pay the surety deposit. This is akin to a lease agreement. If you don't have consideration, the whole thing has to fail as a matter of law. The failure to pay that surety deposit.
All right, first and foremost, you go before the constitutional law scholar himself, Judge Slaven, and you said it has to fail as a matter of law. Ooh, you better know what you're talking about. Just saying. This gets a little heated. It gets a little heated. Just so we're aware. There's a lot of, legal stuff. There's legal sparring going back and forth. It's kind of fun. And then Judge Slaven's like, yeah, cut it out. This is what's going on.
It rendered this license void by its own terms and cannot be enforced.
He didn't pay a security deposit for a campground or something. He didn't pay, but he changed it from security to surety. That doesn't make sense to me. But he didn't pay his deposit for something. Therefore, the contract that he thinks is valid is not valid because he didn't pay that. That's all we know so far. Hope that helps, Sparkle Boots.
Against my clients any longer. Mr. Wehrmeister in his affidavit says, well, I made multiple good defense to pay. After the property had already been sold, he makes an attempt. After the license had already commenced, which should have been paid and wasn't. He says that he contacted his attorney about efforts to pay the surety deposit. That's the licensing agreement says that all communications between the parties should be to my client by email. He's not produced an email that he attempted to pay the surety deposit. He didn't ask them, where did I do this? He just comes to court today in hindsight and says, well, I discovered it had already been transferred, and I had contacted my lawyer.
Oh, thank you so much, Deb. Yeah, I am a gentleman. I am a gentleman. Oh wait, were you referring to Judge King? Oh yeah, he's okay. He's pretty cool. Yeah, I'm just kidding. He might be the coolest person I've met, since the last interview I did. But no, Judge King was awesome. He was awesome. If you guys haven't seen that, go watch that. Go watch that. It was so much fun. Yeah. I don't have to say anything. Judge King, his aura speaks for himself. So, yeah. And as Rachel said earlier, we did a little mock trial for I Pretended to Be a Soft Sit. And it was kind of fun. It was kind of fun. It lasted about 30 seconds, and he destroyed me because, you know what? Soft sits don't win. But anyways, it was still fun.
Prior to that time. That's not a valid defense to this, to our affirmative defense that we claim this agreement is void and is canceled by its own terms. And I think that this court, doing a lot of landlord-tenant type law, knows if you don't have consideration for a lease agreement, if you don't pay the required security deposit, and the agreement says if you don't pay this, you don't have a term. That's what we have here, Judge. This agreement was canceled. My clients sold the property 3 months later after the gentleman failed to even show up or attempt to exercise the June 2023 commencement term. No notification was provided to them. They've provided an affidavit to that effect that he never contacted them. He never gave them a list of people that were coming. They sold the property, thought he had abandoned his license. It wasn't aching on them to reach out to him to say, "Are you going to pay this?" The agreement required it to be.
Katie, that deserves a pause. That deserves a pause. To all my haters out there, I hope you understand that Katie deserves a congratulations. Congratulations, Katie, on retiring. That is awesome. Congratulations. Yeah, now you got to figure out what you're going to do next. Do you know how to edit videos? I need an editor. You want to edit videos for me? I can't pay you much, but if you want to know how to do that, if you want to figure out how to do that, you can do that next. But honestly, congratulations. That is awesome, Katie.
Paid, it wasn't. Therefore, we're asking that the court dismiss this case as a matter of law and fact, because the failure to pay the consideration was clearly demonstrated in this case. Thank you, Your Honor.
Counsel?
Thank you. We are here today for defendant Steelman's motion for summary disposition. The main point of contention being the cancellation of plaintiff's license to use the Kenton Mission hunting property for around 6 weeks a year. That was extended by court order of the Houghton County Circuit Court until September 30th of 2027. Given the standards of MCR 2.116 C8 and C10, plaintiff's complaint, when viewed in a light most favorable, presents enforceable claims, and defendant's motion for summary disposition should be dismissed. Defendants only present a single argument in their motion that the court lacks authority to interpret contracts, but that fails where, first, the contract between the party is both a license and then an additional order which extended that license. And two, there is no requirement contained in that license for the deposit to be paid immediately prior, and there's no, or to who, or to when. So there was no breach of Mr. Wehrmeister by missing the initial 1 week in June when he had reached out to his counsel to confirm next steps, which I have seen emails between Wehrmeister and his prior counsel, and those are listed in our discovery materials. They just haven't been provided given a privilege issue, but I've discussed that with Mr. Speck. The order between them, this was also an example of bad faith, we believe, given that these parties were under some sort of an agreement. They should have at least reached out and say, hey, we're intending to sell the property. It wasn't until Wehrmeister and his counsel reached out after Wehrmeister tried to pay the deposit into escrow when he learned that the property was sold in August of 2023 after he had only missed the first initial term. And as counsel brought up, there are expanded license rights in the state of Michigan provided by case law that if the license is more indicative of a lease or an easement, they may be expanded protections. While we're not arguing that Mr. Wehrmeister had a lease in this case, I do think the license provided is more akin to a lease, given that there was a deposit to be paid. He was allowed to bring his dogs and guests. He was on the hook for utilities. So for that reason, there should have been at least a little bit more communication or a notification regards to a deposit, not a, if you do not immediately exercise this deposit after a history of a dispute between the parties that required not only a mediation, but then a follow-up hearing before the Houghton County Court to enforce that mediation order after my client was prevented from exercising his rights, that there should have been at least a notification to my client before selling the property in secret a mere couple months later before the majority of his actual term commenced. So for that reason, we are asking that this motion be dismissed. and that our case be continued to trial.
Response, Judge?
Go ahead, Counsel.
Your Honor, counsel's attempting to litigate a litany of issues that aren't before the court. We did never have alleged that the court is interpreting this contract. What we said is when the contract is clear, there's nothing left to interpret. The clear term says the term of the lease is for a period of time. It was modified when the order was entered as to what that term was. It says that the surety deposit of $500 for the term will be paid. It says that a violation of any term of this lease results in immediate cancellation. Mr. Wermeister litigated and litigated and litigated, and then he came up with an agreement that he failed to comply with to pay the required consideration. Yes, it's a very harsh result, but the agreement has a harsh consequence. It says, and I'm going to quote it one more time, violation of any term of the license results in immediate cancellation. It's over. It was over when the term began and he failed to pay the required security deposit. He failed to show up. It's done, Judge. All these other issues that counsel raises about he attempted to talk to his client, his attorney, is hogwash and does not change the substance of what happened here. The failure to pay consideration is basically it's the end of the case. And we'd ask that you dismiss this matter.
All right. So we've heard from both sides. Guess ready here, Judge Slaven? Are you ready? I don't think you are. He's good. He's good. And if it wasn't for this speech, I wouldn't have put this in because at this point I was like, but yeah, Judge Slaven just has a way to not only say what the law is, but also educate you and you know what, put you in your place all in one sentence. Just as like his tone and his charisma and his confidence. Yeah. All right, let's go. It's all right. It's about to go down.
Counsel, anything further?
I would just add that I echo that there has been no violation that would warrant the termination. Per the terms, the licensee will maintain a surety deposit of $500 for the term of the license, returned to licensee upon the expiration to the licensee. There is no term about that had to be paid immediately. It had to be paid to his clients directly, and it had to be paid before the initial term, and he was not allowed to skip terms. I believe that they are reading in a violation where it doesn't exist.
I have one.
Okay. All right. Now I thought they were done talking. I'm sorry. But yeah, this is definitely a very big court nerd way to end tonight's stream. But you know, I had some heavy cases on earlier, so I wanted to do it. I didn't have anything to make you laugh, so I wanted to end it with something that wasn't going to put you to bed with nightmares. Just yeah. All right. There's not that much time left in this video, so you guys are all great. I will pause it one more time at least because there's still I think 7 minutes. So I think 3.5 minutes is my pause time. So all right, Judge Slaven, let's go.
Question, Ms. Thompson.
Mm-hmm.
You have the license, and just for the record, it is not a lease. A lease is an entirely different thing. Because if this lease was there and at the expiration of this lease, there would be no holdover tenancy that would apply, and Michigan law would not therefore then put in a de facto month-to-month license. That's why there's a lease and there's a license. They're two different things. This is a license. So, and which is a very specific use of a property under terms that are agreed upon between the two parties. Now, here, they spelled out all of the factors that create this lease and what the terms of the lease are. So, Ms. Thompson, I just have one question. This license allowed your client to go to we'll call it the camp, during the second week of June, which isn't very specific as to an actual date, just whatever the second week is. September 23rd through 30th. And during the period of from between October 27th and November 30th, during the years of the lease, which would be from October 2022 to September 2026. That's correct statement so far?
Yes, correct.
Okay. On December 1st, if Mr. Steelman had gone to the property and the firewood supply was empty, would this license be violated pursuant to paragraph 7?
Not technically, as long as
It's
my
a yes or,
client.
it's a yes or no, it's a yes or no. Paragraph 7 says licensee will fill firewood supply upon leaving. So upon leaving, how long does that last upon leaving? You get a month after you leave, you get 2 months after you leave? No, once you leave, you leave. Once you leave, you left. And the leaving is done. Once you walk off the property, ready to go home, that firewood better be full. And if not, that's a violation of this lease. All right. The licensee will provide his own bedding for his use. Okay. Those are just normal type things. But the thing is, once this came into effect, it's in effect. At the time when both parties sign, that's when it's in. When you have acceptance, offer, acceptance, consideration, and contracts, boom, you have a contract. When does a contract exist? At the point at which there's offer, acceptance, and consideration. When you guys were in court in what county was this, way up north? Anyway, or what circuit? Anyway, once they came to an agreement, put pen to paper, signed it, and the judge signed that order that said, yeah, we're gonna go ahead and agree to that and dismiss that case. That is a done agreement. It is on right then. At that point, it was active. If there wasn't the $500 into the surety deposit pursuant to this, I mean, it can't be any more clear. It doesn't say when you get around to it. It doesn't say maybe, you know, if we need you to put in a five. You know, it says that has to be in place and it will remain in place for the entire term. What does term mean? Term means from beginning to end. So when the beginning came and you didn't have it right from the beginning, right at the very beginning, you didn't have it, your client didn't have it in there. It's one of the material terms, not a sort of head scratcher. I think I gotta sort of look at ancillary and outside facts to figure it out. It's one of the four corners doctrine parts of the material actual agreement. Should have been already, that would have been the first thing. If I was representing that guy, I would have been like, hey, you got that $500 thing before that better be in place right now. So the fact that he went ahead, and how long before they found out that there wasn't this $500 even in existence, Mr. Speck?
They never got notification of it. They never knew anyway. They never got notice of it, Judge. Never.
Okay. So the fact that you go in there, negotiate.
All right, that wasn't what he was asking. But anyways, I'm gonna let this video play out. You guys are seeing what's going on. You guys are all awesome. Let's go hang out on Discord after this. Let's have a good night. This Thursday, tomorrow's Friday, starts the weekend. Yeah, let's finish off the week with a good night. Yeah, let this play out. You guys are all awesome. Thank you all for the super chats, the memberships, the gifted memberships, the new members, everybody. Let's finish the week off strong. And if you want to, come hang out on Discord with us. But until next time, bye.
Negotiating, and then in bad faith, you don't even do one of the material terms. There's only, I just lost my page. Hang on a second, let me get back to it. Come on.
gonna send down the latest, please, okay? So
Like 13 or 14 paragraphs in it.
13 sentences, actually.
13 sentences for 13 pauses. Thank you so much, Legal Fiction, for the $5 super chat. Did you pause? Yeah, I can't deny it. I paused. Thank you so much, buddy.
Yeah, I mean, yeah, right. I mean, but in the legal terms, we'll refer to them as paragraphs. But yeah, at 13 sentences, there's only 13 paragraphs in it. So 1 out of 13 is like 8%. Like that's like, I mean, it can't be any more clear. It had to be in there. So for the reasons stated in on the record and in the defendant's brief in support, I am granting the motion for summary disposition as a matter of law under 2116 C8 and C10.
Well, then I lose then. I lose, Sparkle Poots. I lose. Thank you so much for the super chat. I appreciate it. Also, I was going to pause it again because I just did the 1 out of 13, 8%. I mean, it's 0.076%. Rounded up. That is 8%. He did that on the fly. Good. 1 out of 13. That's not, that could be something you can remember, but still. Good job, Judge. Good job. Just nailed it out the park. Jedi, thank you so much for the $5 super chat. Oh, what the hell? Legal made me do it. Yeah, you know what? Sometimes legal makes you do things. I'll tell you something, though. If he ever tells you that he's not recording, don't trust him. He's always recording. Just saying. Just saying. Just kidding. Love you, legal. Thank you, Jedi.
And as a matter of fact, in law. Counsel, send the order on that. Was there a proposed order?
I didn't, Judge. I'll send it.
All right, via the portal or the email.
Yep.
All right.
Thank you, Judge.
Both parties have a good rest of your day.
You too. Thank you, Judge.
Is that 2 nights in a row where you got the thanks what? Legal, I'm gonna start calling you thanks what. You are now thanks what. Legal Fiction, AK, definitely not thanks what. That was last night, wasn't it? Were you? I paused it right when you did. Yeah. Anyways, I didn't do nothing. You know what? I believe you. Thank you so much for the super chat, Legal Fiction, and Sandy. Oh, didn't click it. Thank you so much, Sandy. Now Colin is a winner. Colin's a winner. Yeah, I've been a winner all my life. I just didn't know it until you just said that. So thank you so much, Sandy. I appreciate the super chat. Sparkle Poots. Wait, already paid for? I want a refund. I've got this really cool. It's a cylinder type object in the corner of my kitchen that I take all of my refund requests and hate mail, and it sits in the corner of my kitchen, and so I will insert your any type of formal request right into that, and I will get to it eventually if the garbage man doesn't take it first. Sparkle, love you. I hope you're having a great night, Sparkle. Thank you so much for the super chat. The Rena. Yes, you did, Legal Fiction. Yeah, Legal Fiction's always doing stuff wrong. He is. Don't trust Legal Fiction. His name is Legal Fiction. Don't trust him. All right, you guys are all awesome. Let's go hang out on Discord. Have a great night, everybody. I'll probably be in Discord in about 10 minutes. I'm going to call Heather. So Heather, if you're Heather's still awake, but Matt, I don't know. So, but Heather, if you're listening, I'm about to call you in a minute, and then I'll jump into Discord after. You guys all have a great night. I will see you all tomorrow. And that's fair. You are the straw man. I mean, you pick the name. You can be, I picked the name Colin. It's it fits. You picked the name Legal Fiction. I'm just gonna have to believe your name. All right, you guys are all awesome. Have a great night. And again, thank you all for watching. Until next time.